All rise. The Royal Commission into the Robodebt scheme is now in session. Please be seated.
Welcome to this initial hearing of the Robodebt Royal Commission. I'll ask the official secretary to the inquiry, Ms. Lai, to read the letters patent. Ms. Lai.
Elizabeth II, by the grace of God, Queen of Australia and her other realms and territories, head of the Commonwealth. To Ms. Catherine Ena Holmes, ACSC, greeting. Acknowledging the harm caused to affected members of the Australian community by the debt assessment and recovery scheme known as Robodebt, the Robodebt scheme, which reportedly comprised from 1 July 2015 the PAYG Manual Compliance Intervention Program, including associated pilot programs from early 2015 to 30 June 2015, and the following iterations of this program: A, online compliance intervention, which applied to assessments initiated in the period from or around 1 July 2016 to on or around 10 February 2017. B, employment income confirmation, which applied to assessments initiated in the period from on or around 11 February 2017 to on or around 30 September 2018. C, check and update past income, which applied to assessments initiated after, on or around 30 September 2018. And that D, in November 2019, the Federal Court of Australia declared, with the consent of the Australian Government, that a demand for payment of an alleged debt under the Robodebt scheme was not validly made, and E, the Australian Government had adopted the same or a similar approach in calculating and raising debts against hundreds of thousands of other individuals under the Robodebt scheme, and F, the Australian Government subsequently announced that over 400,000 debts raised under the Robodebt scheme would be zeroed or repaid. Now, therefore, we do by these our letters patent, issued in our name by our Governor-General of the Commonwealth of Australia, on the advice of the Federal Executive Council and under the Constitution of the Commonwealth of Australia, to the Royal Commission Act 1902 and every other enabling power, appoint you to be a Commission of Inquiry and require and authorise you to inquire into the following matters. G, the establishment, design and implementation of the Robodebt scheme, including 1, who was responsible for its design, development and establishment. 2, why those who were responsible for its design, development and establishment considered the Robodebt scheme necessary or desirable. And 3, the advice, process or processes that informed the design and implementation. And 4, any concerns raised regarding the legality or fairness of the Robodebt scheme. H, the use of third-party debt collectors under the Robodebt scheme. I, in relation to concerns raised about the Robodebt scheme following its implementation. 1, how risks relating to the Robodebt scheme were identified, assessed and managed by the Australian Government in response to concerns raised by the Australian Taxation Office, other departments and agencies, affected individuals and other peoples and entities. 2, the systems, processes and administrative arrangements that were in place to handle complaints about the Robodebt scheme from members of the public affected by the scheme, their representatives or government officials and staff. And 3, whether complaints were handled in accordance with those systems, processes and administrative arrangements, and in any event, handled fairly. And 4, how the Australian Government responded to adverse decisions made by the Administrative Appeals Tribunal. And 5, how the Australian government responded to legal challenges made or threatened legal challenges, and 6, approximately when the Australian government knew or ought to have known that debts were not or may not have been validly raised. And 7, whether the Australian government sought to prevent, inhibit or discourage scrutiny of the Robodebt scheme, whether by moving departmental or other officials or otherwise. J, the intended and actual outcomes of the Robodebt scheme, in particular, 1, the kinds of non-pecuniary impacts the scheme had on individuals, particularly vulnerable individuals and their families, and 2, the approximate total cost of implementing, administering, suspending and winding back the Robodebt scheme, including costs incidental to those matters, such as obtaining external advice and legal costs. And we direct you to make any recommendation arising out of your inquiry that you consider appropriate, including measures needed to prevent a recurrence of any failures of public administration you identify, and without limiting the scope of your inquiry or the scope of any recommendations arising out of your inquiry that you may consider appropriate, we direct you for the purposes of your inquiry and recommendations to focus on decisions and actions taken or not taken by those in positions of seniority. And we further declare that you are not required by these our letters patent to inquire or to continue to inquire into a particular matter to the extent that you are satisfied that the matter has been, is being, or will be sufficiently and appropriately dealt with by another inquiry or investigation or a criminal or civil proceeding. And we declare that you are a relevant commission for the purposes of sections 4 and 5 of the Royal Commissions Act 1902. And we declare that you are a Royal Commission to which item 5 of the table in subsection 355-71 of Schedule 1 to the Tax Administration Act 1953 applies. And K, we require you to begin your inquiry as soon as practicable. And L, require you to make your inquiry as expeditiously as possible. And M, require you to ensure the inquiry is conducted in a professional, impartial, respectful and courteous manner, including appropriately managing any actual or perceived conflicts of interest. And N, require you to submit to our Governor-General any recommendation that you make before making them public. And O, require you to submit to our Governor-General a report of the results of your inquiry and your recommendations not later than 18 April 2023. In witness, we have caused these, our letters to be made patent. Witness General the Honourable David Hurley, AC, DCSC, retired Governor-General of the Commonwealth of Australia, dated 18 August 2022, by His Excellency's command, Mark Dreyfus, Attorney General.
Thank you. As you've heard, it is the task of this Royal Commission to examine, report on and make recommendations in relation to the Robodebt scheme. That's the collective name for the different iterations of the Centrelink program of requiring benefit recipients to respond to employment income figures provided by the Australian Taxation Office. Entitlement to social security benefit depends on a recipient's actual earnings in the fortnight for which benefit is paid. But the underlying premise of the Robodebt scheme was that if a recipient's average fortnightly income, calculated on ATO supplied figures for a financial year, exceeded what they had declared as earnings in any given fortnight in that year, it could be inferred that they had been overpaid. That notion of averaging was not new. What changed with the implementation of the Robodebt scheme in 2016 was that the Department of Human Services began the use of an automated process to demand information from current and former recipients on a scale not previously attempted. The benefit recipient was required to displace what was effectively a presumption of overpayment based on the ATO's financial year information. In some instances, recipients were required to demonstrate that the averaged ATO figures did not reflect their actual fortnightly income for periods going back years. If the recipient could not or did not do so, the department proceeded to use its debt recovery powers without any further attempt to substantiate the alleged debt. The premise for the scheme was unsound because it treated average earnings as though they were actual earnings. But that was most unlikely to be true unless the recipient earned the same amount every fortnight. The very circumstances which caused people to need benefits meant that it was very improbable that many did. Indeed, in November 2019, the Federal Court made a declaration, with the Commonwealth Government's consent, that averaged income information was not capable of satisfying a decision maker of the existence of a debt. That conclusion had already been reached by a number of decision makers in the Administrative Appeals Tribunal over the preceding years. It now falls to this Commission to examine how it was that the Robodebt scheme and to consider the way it was actually put into effect and the appropriateness of the mechanisms used, particularly in light of the difficulties faced by the groups to whom it was directed, and to examine the way that the government responded to concerns raised and how it went about recovery of the supposed debts. After Senate committee inquiries and reports from the Commonwealth Ombudsman, Auditor General and Information Commissioner, a good deal is known about how the Robodebt scheme operated, but not much has been revealed about why, about what advice or consultation or reasoning or response to criticism was occurring behind the scenes at any stage. Many people at different levels of government will be asked to give an account of their role in the devising, implementation and continuing of the Robodebt scheme, but the focus, appropriately and in accordance with the terms of reference, will be on those in senior positions who had, or should have had, oversight of it. The broader costs of the scheme to the Australian economy will be reviewed, and, crucially, the Commission will examine how the program affected the recipients on whom demands for information and payment were made. The Commission invites submissions from anyone who has knowledge of the Robodebt scheme at a personal or organisational level. Submissions can be made online in paper form or in paper form. The website has details. I particularly want to encourage people who had experience with the scheme as benefit recipients to give their accounts. This was a difficult, stressful time in the lives of thousands of people who were told they had debts to pay. I understand that many just won't want to revisit the experience, but submissions by those who are prepared to describe what happened in their case will be very helpful indeed in establishing the detail and the human impact of what occurred. And as the most practical way of illustrating the reality of what happened to individuals caught up in the scheme, the Commission will ask some of those affected to give evidence and will present their experiences as case studies. I'm well aware that prospective witnesses to the Commission are to be found all around Australia. However, given the time and means available to it, it is unlikely that the Commission will sit anywhere but Brisbane. Accordingly, we expect to make use of audio-visual links to take the evidence of some witnesses, particularly that of individuals affected by the Robodebt scheme who are unable to make their way to Brisbane. Other witnesses will be required to attend in person. Some Royal Commissions carry out their functions over years. This is not one of them. I must report by 18 April next year. 8 months is not long in which to set up a commission, uncover a great deal of information, set about discovering what lay behind the implementation and continuing of the scheme, reach conclusions, and endeavour to provide useful recommendations towards better policy development and implementation in the future. It will be necessary for the Commission to operate briskly and efficiently in order to fulfil its tasks in the time available. And with that need for expedition in mind, having said all I wish to at this point, I will ask Counsel Assisting, Mr. Gregory, to give his opening. Mr. Gregory.
Commissioner, I appear today with Mr Angus Scott, Ms Renee Berry and Ms Salwa Marsh. The Attorney-General appointed each of us to assist this Royal Commission into the Robodebt scheme as it is described in the letters patent. Less than 5 weeks ago, the Prime Minister announced the establishment of the Royal Commission. An even shorter period of time has passed since the engagement of Counsel assisting the Commission, our instructing solicitors and the appointment of Commission staff. The date by which the Commission is to report, as you just identified, Commissioner, is 18 April 2023, and there is an obvious need for focus and efficiency to complete the task by the due date. I will outline the broad context for the nature and scope of the inquiry before I address how the Commission will operate. Turning firstly to the context for the inquiry. This Commission is not tasked with replicating the various inquiries and investigations into the Robodebt scheme which have taken place, although much of the content of those inquiries is relevant to the scope of the Commission under the letters patent. The reports which have been produced from those inquiries and investigations are also relevant, at least to the history of the Robodebt scheme and decisions to continue it. The letters patent direct the Commissioner to inquire into the specific factual matters which are set out, with a focus on the decisions and actions taken or not taken by those in positions of seniority. The factual inquiry, with its focus upon the role played by those in positions of seniority, will be the basis upon which the Commission makes recommendations it considers appropriate. Those recommendations may include recommendations needed to prevent a recurrence of any failures of public administration which are identified in this inquiry. The reference in the letters patent to the identification and prevention of the recurrence of any failures of public administration bears close similarity to a phrase which appeared in the reasons of Justice Murphy of the Federal Court when His Honour approved the settlement of the class action brought in respect of the debts raised and collected by the Robodebt scheme. His Honour's reasons, published on 11 June 2021, included the observation that those proceedings exposed a shameful chapter in the administration of the Commonwealth social security system and a massive failure of public administration. The reasons for judgment in the settlement of the class action are, as I indicated earlier, one of the many previous findings of others which are relevant to the Commission's task. The decision of Justice Murphy marked a significant occasion when the Australian Government admitted that asserted debts based solely on income averaging from Australian Taxation Office data were not validly established. In that context, the Commission is to inquire into a number of specific matters which were read out at the commencement of this initial hearing. In summary, the establishment, design, development and implementation of the Robodebt scheme, which raised and recovered debts for the Australian Government and which it later admitted it could not validly establish. Who was responsible for the scheme and why they considered it necessary or desirable. The use of third-party debt collectors in the scheme. The responses to concerns raised about the scheme, the systems implemented to address those concerns and what was known by persons in seniority as the basis for those responses, and the intended and actual outcomes of the scheme. Can I turn now to what is known about the Robodebt scheme? The Commission has already started its work, and I'll provide a brief overview of some of the relevant events which ultimately concluded with the admission made by the Australian Government to which I referred earlier. The existence of Centrelink and its role is common knowledge amongst members of the public. It is the service delivery agency for a majority of Australia's social welfare payments. In 1991, it gained the ability to cross-match its data with data from the Australian Taxation Office. Cross-matching data enabled Centrelink to compare income declared to the ATO with income declared to Centrelink by persons who claim social welfare payments. The ATO continued to provide data to Centrelink since that time under various processes. For the purpose of this inquiry, the ATO disclosed income information to Centrelink, which reflected the income information provided to the ATO by employers in the form of a PAYG summary. That summary often covered the whole of the financial year, but in some cases, the information related to a shorter period of time within the financial year. In contrast to the information provided to the ATO by an employer, Centrelink required information which usually related to a person's actual fortnightly income when it decided whether a person was entitled to social security payments. Prior to the implementation of the Robodebt scheme, Centrelink's calculation of overpayments or debts by analysing the ATO data and the Centrelink records involved direct human oversight by compliance officers according to the processes established within Centrelink. That process included the requirement that evidence was required to support the claim that a legally recoverable debt exists. Debts which were established according to Centrelink's processes were able to be recovered in a variety of ways, including withholding social security payments or a portion of those payments, the garnishee of annual tax returns, and orders made on successful criminal prosecution for debts which amounted to a fraud against the Commonwealth. Often the overpayment of social security resulting in a debt did not involve dishonesty, although the allegation of a debt can attract the stigma of fraud. The complexity of Australia's social welfare system was the subject of at least one report, publicly released in February 2015. That report directly addressed the many types of social welfare payments, the related complexity of the claims and administration processes in respect of each payment. On 1 July 2011, Centrelink was absorbed into the Department of Human Services. The Department of Human Services was responsible for the administration of the social welfare system through Centrelink. The department was renamed Services Australia in May 2019, but its function of administering the social welfare system through Centrelink remained unchanged. Going back to 2011, a government initiative announced improvements to the debt recovery process, which included the automation of cross-matched data between Centrelink and the ATO on a daily basis. That automation was expected to increase the ability of the government to identify and then recover debts. The Commission understands that the identification of a debt continued to be subject to Centrelink's processes, which involved compliance officers using Centrelink's statutory powers to obtain evidence from employers and other sources to sufficiently and therefore validly raise a debt. The decision to raise a debt turned on the assessment by a compliance officer after undertaking that investigation. From 2011, the data matching program identified approximately 300,000 discrepancies annually between the ATO data and the Centrelink data, and of those, approximately 20,000 were the subject of assessment and decisions by a compliance officer. In 2013, the Department of Social Services was created. It replaced the majority of the functions of the Department of Families, Housing, Community Services and Indigenous Affairs. The Department of Social Services worked closely with the Department of Human Services. Broadly speaking, the Department of Social Services was responsible for the development of social policy advice for the Australian Government, which was administered by the Department of Human Services through Centrelink. On 12 February 2015, according to the report of the Commonwealth Ombudsman into the Robodebt scheme dated April 2017, the Department of Human Services sent an executive minute to the Minister for Social Services, which was copied to the Minister for Human Services. That executive minute proposed a new online approach to compliance with the social security system, which would allow the Department of Human Services to review all discrepancies going back in time to the 2010-2011 financial year. The new online approach to compliance was soon described as the Online Compliance Intervention Scheme. It was the first form of the Robodebt scheme. That executive minute must have been produced after some planning, but it has not yet been made public by the Australian Government. According to the Ombudsman's report, the intended main efficiencies of the Robodebt scheme reflected in the executive minute by identifying discrepancies between the ATO data and the Centrelink data were as follows. The capacity to undertake hundreds of thousands of compliance interventions, automatically generating letters to customers notifying them of the discrepancy in reported income, relieving Centrelink of its responsibility for obtaining information from employers and third parties pursuant to its statutory powers before raising a debt, transferring the responsibility of proving a debt from Centrelink to a customer who then had the responsibility of disproving a debt, and moving much of the debt management process to an online process in which customers had to enter information directly into the online system. The scheme was foreshadowed in a press release in May 2015 by the then Minister for the Department of Social Services in conjunction with a budget release of the 2015-2016 budget measures by the then Treasurer. The scheme was projected to create savings of $1.7 billion over 5 years. A small two-stage pilot program was carried out in 2015 and the scheme commenced on 1 July 2016. It was fully implemented 2 months later on 1 September 2016. There were a number of flaws in the system which, if not actually known at the commencement, were publicly identified soon after the implementation of the scheme. The flaws, including the fundamental flaw, which was admitted by the Australian Government in the Federal Court, were specifically drawn to the attention of the then Minister for Human Services by the Australian Council of Social Service, ACOS, in their letter of 21 December 2016. That letter identified consistent reports of debt creation by averaging annual income over 26 fortnights, contrary to the actual fortnightly entitlement test, with the consequence of a false notice of overpayment. In a follow-up letter to the Minister on 19 January 2017, ACOS called for an immediate end to the automated debt recovery system and reiterated its deeply held concerns that the scheme involved the following: the reversal of the onus of proof onto people receiving payments, a failure to properly investigate the accuracy of automated data matching, a lack of human involvement in the detection of and calculation of overpayments, the requirement for people to gather evidence from up to 6 years earlier, an automated debt recovery and deduction of amounts from people's income support without human intervention, and practical difficulties for recipients speaking with a Centrelink staff member. The Robodebt scheme continued from that point in time for almost 3 years until November 2019. On 28 February 2017, the financial assumptions underlying the objectives of the Robodebt scheme were questioned in a report produced by the Auditor-General. Questions too were raised about the budget assumptions on which the financial objectives of the scheme were based. Those questions are relevant to the scope of the topic of the intended and actual outcomes of the scheme in a financial sense, and also to the questions of the process in which the scheme was developed. The Administrative Appeals Tribunal, the AAT, is the tribunal which decides appeal against Robodebt decisions, amongst others. On 8 March 2017, a member of the tribunal decided an application to review an automatically generated debt under the Robodebt scheme. The debt was set aside by the tribunal member on the basis that there was no evidence of a debt. The decision was remitted to Centrelink to decide afresh according to further directions. Those directions were twofold. No debt or debt component is able to be founded on extrapolations from ATO records, and the earnings component of recalculated debts, as may be raised, must be based on and confined to any fortnightly salary records obtainable in the exercise of Centrelink's statutory powers. In short, the legal framework for the AAT's decision on the merits of the debt was that the online compliance process involving income averaging did not provide evidence of a debt. That finding ought to have been of significance to the Departments of Social Services and Human Services because of its pre-Robodebt policy, which required evidence to support the claim that a legally recoverable debt exists. More AAT decisions followed to the same effect. The Commission expects to receive evidence that more than 20 such decisions of the AAT were delivered up to 30 May 2017, in which it was found that income averaging based on ATO data did not validly establish a social security debt. The Department of Human Services made changes to some aspects of the online compliance system to overcome other inadequacies in the transparency and usability of the online system. However, the fundamental flaw remained. In the face of public questions about the process, ministers and those in senior roles in the Australian Public Service asserted that the system worked well. On 2 March 2018, the Robodebt scheme alleged a debt against Deanna Amato, who then applied for declarations in the federal court, including that the debt was not lawfully raised. On 27 November 2019, orders were made with the consent of the Australian Government to the effect that the demand for payment of the alleged debt was not validly made to Ms Amato because the information relied upon was not capable of proving a debt. That is the declaration referred to in the letters patent. On 18 November 2019, that is less than 2 weeks before the government consented to the order in Ms Amato's case, Services Australia, formerly the Department of Human Services, announced that it would not raise debts in sole reliance of apportioned ATO data, that is, averaged income. On 20 November 2019, the class action was commenced in the federal court. It was a further 6 months before Services Australia announced it would repay approximately $721 million in debts raised by the Robodebt scheme against approximately 381,000 Australians, and it was in July 2020 when it announced that it would withdraw all debts raised of approximately $398 million based on income averaging from Australian Taxation Office data. The settlement of the class action involved the remaining claims for interest and costs, which amounted to a further $112 million to be paid by the Australian Government. The reasons of the court referred to evidence which showed that the Commonwealth Government asserted debts totalling at least $1.7 billion against 453,000 Australians during the life of the Robodebt scheme. That brief overview provides a sufficient factual context for the specific questions which are set out in the letters patent. That said, we are aware of the temptation to prejudge matters based on previous reports and inquiries, and we will avoid doing so. Counsel assisting will consider the subjects of this inquiry with fresh eyes to assist the Commission to determine these matters according to your position of independence. Can I turn now to how the Commission will operate? The Commission will undertake its work in 4 primary ways. First, it will receive submissions through the Robodebt Royal Commission website. Submissions can be made which are relevant to the matters set out in the letters patent by following the prompts on the website. Those prompts will guide submitters through the process of making a submission online. It allows persons to answer questions and to attach documents. The submissions need not be limited to past events, nor do they need to be limited to recipients of entitlements who had a debt calculated according to the scheme. This Commission is vested with the responsibility of making recommendations which may affect the processes by which the Australian Government exercises its powers in the administration of the social welfare system. Those processes affect the lives of many Australians on a daily basis. Persons or organisations who, by reasons of their profession or experience, can provide meaningful contributions to the work of the Commission are welcomed. I can appreciate that many people and organisations have already provided information and submissions to inquiries by the Senate, the Commonwealth Ombudsman, and in court or tribunal proceedings. The role of this Commission is different from those previous inquiries and investigations, but the information and submissions provided previously remain relevant to the work of this Commission. The online submissions link is now open. The Commission will analyse the information and submissions which are provided over the coming months, and it will form a significant body of material which will assist the Commission to make its findings and recommendations. The opportunity to provide submissions on the Robodebt Royal Commission website closes on 3 February 2022. I encourage members of the public and organisations who can speak to the subjects of the inquiry in the letters patent to take the time to prepare or update their submissions and lodge them online. It is important to bear in mind that only a small number of those who make submissions will be able to give evidence in the public hearings. The second of the 4 primary ways in which the Commission will work is the public hearings, but before I do that, can I say this? Those who wish to make a submission but do not wish to have their name made public can do so. The online process allows for anonymous submissions to be made. I note also that the Royal Commissions Act 1902 provides protections for witnesses who give evidence or produce documents as required by a notice from this Commission. It is an indictable offence for anyone to cause or inflict any damage, loss or disadvantage to someone on account of them appearing and giving evidence or producing documents under a notice. Second, as I said, the Commission is in the process of sending notices to government departments, agencies and individuals to provide documents, information and statements. That process will continue as relevant documents are identified. The matters into which the Commission must inquire go back many years. The contemporaneous records held by the Australian Government are critical to the task before the Commission. The nature of the material requested will be targeted to the specific matters set out in the letters patent, although we anticipate that the relevant documents to be considered over the relatively short life of this Commission will still be voluminous. Much has to be done to prepare for the first public hearing, and the appointment of this Commission reflects contentions which have existed for a considerable period of time. The material sought by the notices will not be a surprise despite its volume. The turnaround time for the production of material in response to the notices for the first hearing will be short. Third, as I indicated, the Commission will hold a series of public hearings. Oral evidence will be given during the public hearings, which will supplement the submissions, information, statements and other documents received by the Commission. According to the terms of the letters patent, the Commission must inquire into factual matters set out in the letters patent with a focus on those persons in positions of seniority. That will include those who were involved in the decisions to establish the Robodebt scheme, those involved in the design and implementation of the scheme, those who were made aware of its risks, complaints, legal challenges and their responses, those who maintained the scheme, and the information upon which all of those persons made their decisions. The witnesses who will be called to give evidence at the public hearings will reflect that focus. In addition, witnesses will be called to give evidence about the impacts of the Robodebt scheme upon them individually and their families, and the cost to organisations who assisted those affected by the scheme. Evidence on those topics will enable the Commission to report on the actual outcomes of the scheme which cannot be measured financially. Witnesses in this category will of necessity be limited to specific examples and case studies which reflect the experience of many. Fourth, the Commission has started to review previous inquiries, investigations and reports into and related to the Robodebt scheme. There are many such inquiries and reports. They contain relevant factual and historical information related to the factual matters to which this Commission must inquire. I turn to the first public hearings and topics. As you have identified, Commissioner, the limits on time and resources will have the result that although this inquiry concerns people throughout Australia, it will be more efficient for witnesses to attend Brisbane to give evidence rather than for the Commission to relocate for each hearing. There will be audio-visual link facilities for witnesses whose evidence the Commission considers may suitably be given from places outside of Brisbane. It is most unlikely that persons in positions of seniority will be permitted to give evidence remotely. The first public hearing will commence on 31 October 2022 for 2 weeks in Brisbane at this location. Further dates of hearings will be published on the Commission's website. During the first hearing of the Commission, evidence will be adduced about the establishment, design, implementation of the Robodebt scheme, including the following matters: the statutory framework in which the scheme was brought into existence and changes to that framework at or about the start of the scheme, the development of the scheme as government policy, the role of persons in positions of seniority and why the scheme was considered necessary or desirable, and the advice and analysis upon which that view was formed, the extent of planning and testing, whether advice was sought about the lawfulness of the scheme, the role played by the budget process in establishing the scheme and measures necessary for it to commence and to continue, the means of debt recovery, including the use of debt collectors and commissions on amounts recovered, the imposition of a 10% penalty in addition to the calculated debts, and critically, how and at what point did the scheme become automated, and how did the raising and recovery of debts in the scheme differ from previous debt recovery processes undertaken by the relevant department? Those topics are substantial and will fully occupy the first hearing. It is important to establish these matters with precision, as they are likely to shed light on much of what followed in the continuation of the scheme, despite the indicators that it was flawed. The process of establishing these facts will be detailed and systematic. A significant point of distinction between this Commission and previous investigations, inquiries and reports is the authority of the Commission to require the production of documents, information and witnesses. That authority will be used to enable this Commission to carry out its functions. Can I turn briefly to procedural matters? Practice guidelines for procedures, general procedures, leave to appear and witnesses are available on the Commission's website. Further guidelines relating to cross-examination of witnesses and claims for legal professional privilege will be published shortly. Procedural matters such as these will be dealt by the Commissioner outside the time allocated for the hearing of evidence. And on a concluding note, although much is known about the Robodebt scheme, as you have indicated, Commissioner, little is known about some of the factual questions raised in the letters patent. In our role as Counsel, we will assist the Commission to ascertain those facts, which will inform the findings and recommendations this Commission considers appropriate. May it please the Commission.
Thank you. Adjourn the Commission.
All rise. The Royal Commission is now adjourned until Monday, the 31st of October at 10 a.m.